May I ask Lord Denning if you could comment on the enormous change of attitude to the subject of administrative law that has taken place during the time when you were on the bench. I remember so well back in the 1950s, when I was myself first becoming interested in it, how discouraging it was to read a lecture by Lord Devlin in which he said that the common law had lost the power to control the executive and that he could only pronounce a death certificate for it. And now, in the last few years, we have really felt that administrative law has become a highly organized and elaborate subject, very largely thanks to your own judicial contribution. I wonder if you have any feeling why it was in the doldrums for so long, and how this great change came about, and when was the turning of the tide?
Well, I can assure you it was in the doldrums when I was called to the bar in 1923, that's 60 years ago now. There had been a recent case in the Privy Council in which Lord Sumner had declared that the judges and the courts had virtually no control over the decisions of all these various tribunals unless they went outside their jurisdiction altogether. If they decided wrongly, well, so it be. The courts could do nothing, and they did nothing. That was 1923. And it's that situation which I'm sure that Lord Devlin had in mind in the lecture which you're quoting, because by their own decisions, the courts had given up any power to control tribunals or inquiries or ministers. Indeed, at that time, in 1929, Lord Hewart, the then Lord Chief Justice, wrote an important book, The New Despotism, which we read, in which he condemned the failure of the courts to control the executive or the tribunals. But now you ask what the position was when I became a judge. That was 1944, 40 years ago now nearly. It was just the same. Nothing had improved at all. Indeed, I think, although I may say it, not in 1948 when I went to the Court of Appeal. It was first, I think, in 1950 or 49 that Lord Goddard had an important case, all from a compensation tribunal, in which he declared, and we affirmed it in the Court of Appeal, that the courts could interfere not only when the tribunals went outside their jurisdiction altogether, but also when they made an error of law. That was the turning point, I think, 1949 or 1950. Northumberland compensation in Shaw was almost the start of the turning point in the direction which you've now described of a system of administrative law in England.
So then the judges began to hit back, if you can put it that way, and one thing followed after another until suddenly the subject of natural justice was revived by the decision of the House of Lords in Ridge and Baldwin in 1963. Somewhere, perhaps in or between the Northumberland case and the case of Ridge and Baldwin, the tide seemed to have turned.
Well, yes, indeed. In fact, long before Ridge and Baldwin, we knew all about natural justice. We had, I remember in those days, a lot of cases from domestic tribunals. We had the Jockey Club, which had taken away a man's license without hearing him. We had also a little trade union, almost a showman's guild, in which a man had been deprived of his license or right to put on his show without a hearing. And in all those cases, following a lot of cases before about clubs, we held that all these tribunals must act in accordance with natural justice. And we started the natural justice idea, if I may say so, long before Richard Baldwin. We started it in regard to domestic tribunals, as I call them, but then we went on to tribunals of a statutory nature. Indeed, I think we had it in 1937 about police, and we certainly had it. I had a case from the Privy Council in 1960, quite an important case, Kanda and Malaya, in which a police inspector, they didn't let him see the case against him, and we held that was not in accordance with natural justice. In other words, we'd been working along the road towards holding that all tribunals and inquiries must act in accord with natural justice. And it only brought its culmination in Ridge and Baldwin in the House of Lords then.
And I think not only tribunals and inquiries, but ministers, local authorities, licensing bodies, and public authorities of every description.
Yes, indeed, because there is another, it's all going back to that same period when there was the turning point, almost about, from 1944 to 49. Lord Green had an important case, which we all remember ever since, called the Wednesbury case. A licensing body had insisted in regard to a cinema as to whether youngsters under 14 or whatever it is could be allowed to enter, their regulations. Could their decision be interfered with? Lord Green in the Wednesbury case laid down an important principle. You mustn't interfere ordinarily with their discretion as long as they act reasonably. But if they act in a way which no reasonable person could do, no reasonable body so constituted could do, then the courts could interfere. So at the same time, that's in the 1940s, at the same time the courts were beginning to exercise control over these licensing bodies, tribunals, inquiring, from that period on.
I wonder if you have any theory about why it was that this mood of defeatism set in at that time after the war. After all, the foundations of the welfare state were then being laid. It was obvious that a great deal of government power was being let loose. How did the courts not respond more promptly to this obvious need to protect the citizen against abuse of it?
Well, lawyers are the most conservative body of people you ever met. I mean conservatives with a small c. They'll stick by their precedents. I don't agree with that, but they'll stick by their precedents and won't alter them. But as I mentioned earlier on, there was a case in 1923 in which Lord Sumner had said, we can't interfere except when they go outside their jurisdiction altogether. If they go wrong, we can't interfere. That's what he said in 1923. That's the year in which I was called. That's the sort of case I was brought up upon. And of course, going by all those, as we have for precedents for years, although there was only Privy Council, we lawyers followed them. That's the reason why the judges and courts didn't interfere, because they felt strictly bound by this doctrine of precedent. I appealed against that many times without success, but they stuck strictly by their doctrine of precedent, and that's why they felt they could do nothing, because their forefathers hadn't done it for the last 100 years.
That's the Nat Bell case that you're referring to, that came to the Privy Council on an appeal from Canada.
Yes.
Where Lord Sumner laid down some very bad law in
well,
marvelous...
you say it's bad law now then, but we thought it was good law then.
Well, whether good law or bad law, he laid it down in such a marvelously eloquent judgment. It was so quotable and so memorable that the phrases in it about the inscrutable face of the sphinx and so forth were burnt into the conscience of the legal profession so that they could hardly ever get rid of them.
We could quote them off by heart. I could tell you it's inscrutable as the face of a sphinx. If they didn't give any reasons, they just gave their decision with no reasons. You couldn't go behind it. It was inscrutable as the face of a sphinx. And we always quoted that, as I say. and his authority, a great authority, and we went by it all. That's why we didn't interfere. And if you, well, years ago, not only did Lord Hewart in the New Despotism, but I gave some little lectures in 1949 called Freedom Under the Law. And in that very book, in my last 2 chapters, I pointed to the inability of the courts to control tribunals, their inability to control the executive. I pointed to that very time in 1940, the first time I gave any public lectures, if you please. Was on that first of the Hamlin lectures, Freedom Under the Law, and I then said, well, isn't it time we did something? I don't know, I like to think that had some little influence, but all of it, from about that time, a change of attitude struck in.
You referred to that old case of Lord Sumner's as producing a blackout, I think, in one of your judgments in
did.
the recent Air Canada case. And clearly that was one of the causes. But it was so extraordinary that the whole profession and the judiciary seemed to be oblivious of the need for an active administrative law, and then in your time they suddenly woke up to it.
Well, I don't know. I think it was a concerted move. But you see, got to remember, I told you about Lord Goddard's case. Only a few years before, and in fact a year or 2 before, he'd gone by the old doctrine. There was a case in 1947 called King and Ludlow. He was laying down, oh, the courts can't interfere and all that sort of thing. But he led the way almost in that Northumberland case, which we approved. That I did look into it a great deal then, in that Northumberland case. In the Court of Appeal, I had all my books up I have here, and did all my research, and I did look into it and showed, as I hope, that it's only within the last 100 years they got stuck in the mud like this. That previously our predecessors, Lord Mansfield and the rest, had been a much stronger influence and control over these tribunals and so on. And I drew upon that in that Northumberland case. I think that set the tide turning, because I think then we realized that the recent precedents were probably wrong. It's about time we bent back to the good old, the things more than 100 years before.